Hello and welcome to our show, The Awakening, here on WGSN-DB, the Going Bold and Going Solo Network. The information and opinions expressed on this show are just that, the opinions of the individual speaking based on their individual personal experience. They are not intended to diagnose and do not constitute professional advice or recommendations. So you know the pain and the stress and the struggles that divorcing people go through. Well, there is a way to find peace and sanity and assist the lawyer on their legal process, saving you thousands of dollars. My name is Tina Huggins. I am your divorce coach specialist, divorce consultant, restorative family mediator, and conflictual co-parenting coach. And thank you for joining me. Our guest speaker today is Richard Lebovitz, Esquire. So he's our attorney. And Richard is a third-generation attorney who followed the footsteps of his father, grandfather, and brother. After practicing with them over a decade, he moved to Baltimore in 2005. Richard treats every client with respect and integrity, diligently representing their rights. He is a member of several professional associations, including the Baltimore County, Baltimore City, and Maryland State Bar Associations, as well as Maryland Association for Justice. So welcome, Richard. Thank you for joining us.
Thank you for having me.
So as I was going through the questions that you sent over, I always ask for questions to be sent over so that I know how to open things up. And the most interesting question, I've got to set our timer so that I'm paying attention to what I'm doing. And the most interesting question that I had in there was that you put down is to ask how you handle the conflict, the drama, the family drama that comes up. And because my job is to hopefully keep that drama off of your desk, when it does land on your desk, how do you handle that?
That's a great question. Normally, I do my best to really focus on the main issues at hand, and or explain to the clients that it's always about perceptions. That essentially why do you think somebody is doing or is acting a certain way, or why is someone why is someone acting a certain way, why has someone reacted that way, or what's the motivation for saying something, and I can usually figure it out. So if it's a custody battle, and the question is, you're being denied access all of a sudden. It's like, well, do you have a new significant other, or do they have a new significant other, or things of that nature? And you can usually figure out, what's going on. But at least as the attorney, and having been practicing for over 30 years, I know how to kind of focus on the big picture and know how a court would handle these issues, and try and put things in perspective.
Yeah, and I had a client today that they have been kicked off of an email, and they're frustrated about the fact that they can't access this work email and stuff. So my job is to hopefully keep that conversation away from you. And I try to help my clients to understand that this is a drama thing. And so we'll just kind of work on it over here on the sidelines so that by the time they get to you, they're just giving you proof so that you know how to handle the proof stuff. And so when a client would come to you with that type of information, that specific thing that they were kicked off of their work email, how would you handle that with your client?
So if they were kicked off their work email, I'm just trying to figure what is this, like more of an employment perspective that they are being.
They own a business together. They own a business together.
Okay, so then the spouse essentially is turned off or cut them off of their email. So I mean, essentially, then either you have to talk to IT, IT department, or basically log in and maybe fix the password, because clearly somebody is trying to sabotage or cut off their email. Or potentially reach out to all your contacts with a different email. I mean, because honestly, that's just more getting into the sabotage or issues of marital property, or trying to devalue a company, or some kind of goodwill issue. I must say I've not really had that issue come up. And my issue for me is more about business valuations, and usually it's one party is basically running the business, and the other party is trying to figure out what the value of that business is, or get any money as part of a marital settlement from the business. That's not necessarily trying to force them out of business, because if you're in front of a judge, it's like, well, look, is the goal to basically sabotage or reduce their income, whereby you want them to pay alimony or spousal support or child support? I mean, because that's usually very counterintuitive, and to be vindictive like that, again, is this a case involving children? Then basically, if they're doing that for the one parent, then maybe it translates into issues with co-parenting. So I'm just saying, I mean, obviously, I don't know if I'm really answering the question of how I would handle that. Essentially, if it was an attorney on the other side, I'd be like, hey, guess what your client did? And I really don't like going there, because again, then I'm almost lowering myself to their level of like what their client's doing. It's the old, because to me, that never resolves anything.
Right, right. And that's why, like in this specific situation, she finally went pro se. And so my whole thing was, do you need to get on that email? And she said no. Then I told her, then if you don't feel that you need to have any information from the email, leave it alone. Don't let him get to you, and to just document everything so that if and when she would have to hire an attorney again, she had this information. So one of the things that I see, and in this case and all of my cases right now, there's children involved, and there is one side, I work on the most difficult situations. The other side never wants to turn in their financials. That's not like 100% across the board. They don't want to turn their financials in. And then in several of the cases that I'm working right now, the other side is trying to diminish their income so that they don't have to pay so much. So let me ask you this, because that was a twofold. So when you have clients on the other side that are not turning in their financials, what do you do to help that come about to that they can turn in their financials or get them turned in?
Ironically, that's a very common problem I have, especially when people, so for some reason, it's one thing as the attorney, when you're the attorney from the very beginning of the case, until trial, when you have the luxury of filing, interrogatories or requests for production of documents, and then motions to compel discovery, to essentially, and the parties are required to file a financial statement to essentially disclose what their income is. But when someone then hires you later in the game, or 2 weeks before the hearing, or weeks before the hearing, when there's no time to do that, then you're much more limited, because then all you can do is speculate. Because clearly your client can say, well, depending on their relationship, maybe there was some discussion about how much that party was making, or you guess. I mean, if you're on the stand and you're asking, well, how much did your partner make? Because some people have no clue, but you can maybe talk about what expenses, what was your normal monthly budget, what were your expenses, and clearly, if this is how much you made and the bills were being paid, then you can extrapolate what the income would be. Because at least in Maryland, where I primarily practice, the court would always usually impose at a minimum wage job on somebody at $15 an hour here in Maryland. So it's $2,600 a month, and we focus our child support and support stuff on gross income, not net income. So essentially, at a bare minimum, it would be a $15 an hour job at $2,600 a month, or roughly around $32,000 a year. So so I'm at a minimum, that's the number, because otherwise they could be an independent contractor, like a landscaper or someone, or a truck driver, and claim they have no money. And again, you short of getting a joint tax return or some other income, people purposely don't provide that information. Or you could send a trial subpoena if you have time, and at least go for the negative inference in front of a judge. Clearly they're hiding their income. But it's a crapshoot. Especially today, you could also send a subpoena to say for Venmo or Cash App or Apple Pay, because a lot of people like hiding their income. And then when you start, I had a case like this where we brought in the Venmo records, and I was able to show all these deposits from Venmo or Zelle and definitely was able to prove that the gentleman was making lots of money that he wasn't reporting. So it's not perfect.
No, and that's something that I don't, a lot of the people that I've worked with, they just don't understand that when the attorney, they see law. And so this is kind of how I explain it to my clients, is that
Sons of
when
bitches.
I come in from law enforcement, and law enforcement, when you're outside, you're speeding, the law is black and white. If you're doing over the speed limit, you get pulled over, you get a ticket, black and white. But in family law, there's so much that's all gray. And so I try to explain to them that each attorney, and in some cases, the attorney isn't the right one for their situation. Like in your case, you understand what you need to do to compel. I have worked with attorneys that don't like to do the conflict, so they end up having to pass it on because they don't like to do anything that pushes the other side. So we have to have the right attorney for the client in the situation. And so being able to compel the other side to turn in their financials, that is an important aspect for the clients that I have. I try to get my clients, before they get to your desk, to have all of their financial stuff gathered and everything, so that by the time they get to you, they're ready to talk to you about the next step after that, so that you don't have to wade through all of their stuff. So when the other side doesn't turn things in, I have a client they're working with their attorney now, where the other side's refusing to turn things in. So they have mediation coming up, and I talk to them. And so they're going to take their numbers from, they had a certified divorce financial analyst do their financial stuff for them, all but what he wouldn't turn in. And so I said, take those numbers, or the attorney is working with them to take those numbers and take them up to as high as what they can see would have happened. And then when they take it to them, then they at least can come back with their proof as to how much lower it is than the numbers that they have given on financials. So when you have people and they're getting ready to go into mediation and they're struggling because they don't have their financials, what is your recommendation for that?
It's a great question. I have the exact similar issue now with my own clients. Not gave me his 2023 returns, is refusing to give me his 2024s, understanding that he's a self-employed, and he can hide behind the fact that as you would know, that the deadline for providing your financials for your business is not until October. So he's like, oh, I couldn't possibly give you my records for 2024 because I don't have to provide them until October of 2025. And I'm like, well, then give me your profit and loss statement. I mean, there's no good easy answer. Or you basically tell them that if you're in, because mediation is usually non-binding, but if the goal is to save, the ultimate goal is to save you money in litigation costs. So it's either, stop playing these games and either give me the information I need, because the only way I can, try and settle your case is if we work in good faith, provide the information that's being requested. Because even though you could tell me that, oh, my account, like in this case, the accountant's like, oh, they only make, say, $70,000. And I'm like, and the opposing counsel thinks it should be like 100,000. I mean, in the grand scheme of things, if you run our like SASSy-Calc, which is a program for child support we use here in Maryland, it's not really that. It was only like a $200 or $300 difference in the monthly expense. So again, you have to talk about the big picture. And essentially, what are you trying to save or what are you trying to prove when the client's not providing this information? I mean, or essentially, you can't represent that client if they're making it so difficult, because then it's going to be somehow they'll turn around on the attorney and say it's your fault that I just got nailed with a big award, or I have to pay this extra money. And I'm like, yes, but you're not working with me to allow me the opportunity to disprove this idea that you're hiding something, because maybe you're not. It's just that you just don't understand. So again, I agree with you. These are always gray areas. And again, what's your motivation? Are you hiding this because in the past you lived a certain lifestyle, or you had money under the table, or is this really just you just don't want them to know, or you're too proud, or maybe you're not doing as well as they think, and you're too proud to show that. But again, you have to, try and gain the trust of the client, or potentially, walk away and explain to them that it's your reputation on the line, and you can't be mixed up in this. I don't know if I'm
Yeah,
really answering the question. I'm just trying to say that, again, what's the problem, and or the big picture. Like, my solution is, even if you would assume that the other side is correct of how much, and they want to extrapolate or give an earnings capacity argument, showing that maybe your client's voluntarily impoverishing themselves, and they could be making more. Ultimately, the real number may not be that much more than, or it may not be that bad, is the short answer.
yeah, you know, with the clients that I deal with, I'm dealing with the one that's in most cases been abused. Usually it's always got some form of financial abuse in there. And getting the other side to turn their financials in is very, very difficult. And there's been several situations where I have to sit with the client and I have to have them weigh this out. Is paying your lawyer for the next 2 years to get this much money, or working it out and leaving this much money sit on the table today, it's either going to weigh equal, or you're going to end up paying way more to your attorney and legal costs because they're having to pay their CDFAs and the other people helping in their corner to get a smaller amount. And it all, like you keep saying, what's their reason? It all comes down to the hurt and the pain that they feel that they deserve more because they've been injured financially, or in some cases even physically. And getting the client to understand that sometimes walking away is the best way to get back at their pain and the person that caused that pain. Just leave it on the table and go live a happy life, because that's what they're trying to prevent you from doing right now, is living a happy life.
No, I agree. In fact, I was in court earlier today with something very similar like that, with the controlling person. And you're right, it's about the finances. Or like right now, the gentleman owes thousands of dollars of back child support, but was trying to bribe the children with new game systems. And you're like, wait a second, why are they? How's he affording that without paying the support he's supposed to be paying? But no, I hear you. These are all concerns, and that's the thing. You have, at least for me, I can take the 10,000-foot view looking down and try to explain to the client again. I'm glad to fight for you as much as you want me to, but that costs money. And then when I start setting forth, well, this take this many hours to negotiate this, and this is what essentially costs to file this a certain kind of motion or a subpoena to try and get these records, and there's no guarantee we can do all that. And again, if you're trying to prepare for a mediation, that's because you're in a vacuum, and you could be 6 months to a year away from any actual trial. So you're trying to negotiate through mediation to try and resolve your case sooner, right? But the only way that works is if you have the tools and the information in which to make a reasonable and learned decision.
Right, right. Another situation that I see often, by the time that some of the clients come to me, they've been working with their attorney for a while and they feel like it's their attorney's fault. And they come in and they're mad and they want a new attorney. And so I ask them to send me, the communication between them and their attorney. And a lot of times it's that the attorney talks attorney talk, and the client is not understanding what they're saying. So what I do is I go in and I've explained that to them. But in the case with talking with you, you're obviously explaining it to your clients. I see that when they come and they're angry at their attorney, I right away change their communication with their attorney. Said, send it to me, let me clean it up so we get no more emotion. And right away, the attorney has a different response to them, and they don't understand before that why their attorney is not returning their phone calls or answering their emails in a timely fashion, because they feel that because they pay you, that you are at their beck and call and you should do it their way, when it's not the legal way.
Okay, I definitely fallen into that trap a few times. As far as the ebb and flow of business, because a client calls you Like I literally just had a potential new client 2 weeks ago, called me, basically was hired me on Friday morning, and then was firing me on Monday morning because when they called me at 5:30 after hours on Friday evening, and I didn't get back to them until Monday morning. There, I texted. I made the mistake of texting him over the weekend, like I'll try and get back to you, but hey, like how important is this? I wasn't giving them the personal attention that they wanted. And I'm like, but I wasn't even hired yet. That kind of thing. But no, I definitely I understand that, and ultimately it comes down to explaining the process to the client, being transparent, and having them understand what's going on. Because otherwise, it's my fault if they don't fully understand what's going on. If I didn't explain it properly, because they're getting barraged, or they're hearing from all their family and friends, from all these people saying, "Oh, my lawyers, did this to this person, or my attorney did this for you." I'm like, no, those are all just stories. That's not actually that's not what actually happens, right? Or it's like my attorney took them to the cleaners, or my attorney did this and got all this big award. No, there's something that those are all just tall tales. That doesn't necessarily happen in law. Right. And again, if you're all in a vacuum and you're trying to resolve things out of court without having to wait time to go to court, then it's my job to explain the pros and cons and why you should agree, try and reach a compromise.
Yeah. Yeah, definitely. And between now and trial, and then this is the thing is that the attorney sometimes gets blamed for what happens when you go to trial. First, I tell my clients, we're going to do our best to keep you out of trial. We're going to try and mediate it out. We're going to try and communicate it out, so that we don't have to get to trial, because it's never the attorney really that does anything wrong. We are at the beck and call of the judge that's sitting that day. And I have been in the courtroom with the judge that literally must have woke up on the wrong side of the bed, and everybody caught the short end of the stick that specific day. Everybody caught the short end. And even though as an attorney, you do everything that you need to, you've presented everything, your client was upstanding, you had all the right proof, but the way that you presented it and the way that the judge can see it can be two separate ways at the end of the day. And so many clients don't realize that. That's why we don't want him to go to court most of the time.
Well, it's also because a true trial, it's not like us having this conversation right now. It's doing direct testimony. There's issues of hearsay and evidence. Just because you have you may have heard somebody on the phone or in a voicemail, that's all hearsay or privileged information. Essentially, how's that evidence to get into the court? Because here in Maryland, again, you have to have like a consent. If you're if you're walking in the room and someone's on the speakerphone and you're listening in or eavesdropping on a call and you want to then use that as evidence at a hearing, like you're say the other significant others talking to a third party, or the third party is talking to you, and but you want to like use that evidence against them. Well, again, that's either a wiretap problem or other issues that you just can't get it in. Or you're like, oh, I have all this evidence, I have all these text messages. Well, do you want to spend the hours reading through all 100 or 200 email text messages? Most cases now we use AppClose or Our Family Wizard or Talking Parents. At trial, I would come in with 600 pages, from 6 months to a year's worth of messages, and the judge or magistrate would look at me like, I'm not reading that. So all I could do is bring like snippets of like 2 or 3 pages, saying, here's a sample of the kind of communication. But for the client's perspective, do they really want to print out all 600 pages and, for evidence for court, or who's going to read all that? They want to pay me a few $1,000s to sit there and read all 600 pages of their messages for a year. I'm saying, so when you're right, when you're trying to figure out what evidence do you have and time value of money, does it make sense to really go to court? Unfortunately, some people just want their day in court and don't understand that's not what you really want. Because I have like that all the time. I was just there over last week. I was supposed to have a 2-day trial, and the judge was nice enough to do mediation instead. So we spent the whole day, a day and a half, mediating and reaching an agreement. And he's like, well, either you have now 20 minutes, either agree or we'll call your first witness. And ultimately, my client's the one who actually, said, you know what, we were like, wanted to blow the whole thing up over one very minor issue. Again, we resolved custody, we resolved most of the marital property of how the houses and everything else would be sold, and the retirement or pension accounts. But then it was like, oh, I want the lawnmower. And you're like, seriously? So we're saying we were about to blow up a whole deal over that. I'm like, trying to explain to the client that's not how we do things. The judge has now heard all the evidence. You really don't want this to go in trial, because essentially the judge is going to essentially rule exactly what he just heard everything, and you might get less.
Exactly.
But we're saying people sometimes can be their own worst enemy. I assume is the point, and that's
Yes.
why, like yourself, if you're trying to help them understand that, in theory, makes my job easier.
Yes. And that's what I do. My clients all need an attorney. And so the first thing we do if they don't have an attorney is I work through all of the foundation stuff, which is getting all their financials and stuff for you and getting it together, having them put it into my worksheet. So it's real simple for them to move it over into your worksheets. And so we get them all organized, and that usually takes us 1 or 2 sessions. And then by then I understand how their soon-to-be ex is responding to the whole thing. And so I'm able to tell him, okay, well, this is the type of lawyer that's going to work best in your situation. And usually it's somebody like yourself who knows how to litigate, because of that financial issue, they don't turn in their financials. And if the lawyer does not like litigation or doesn't like to push orders to compel, then we're going to be stuck for a good long while. And we don't want to do that. So I help them get a list of attorneys like yourself where they can call in, and I help them put their questions together so that they can hire somebody that fits their situation like yourself. And then the other thing is that they'll want me to sit in on their lawyer meetings. So then before we ever meet with the lawyer, I explain to them what the confidentiality aspect is, so that they understand why attorneys don't want me in the room. Some attorneys do because they have a hard time communicating with their client, but most of them I'm just in the background, and that's the way I communicate with them. The lawyer will send something, I'll be CC'd on it, and I just mark received, and we just go from there.
Okay, no, that's very helpful. I mean, I have no real issues because I would work with other divorce coaches and stuff. They're really not in the meeting, but they would meet with their client and then I would have a conversation with you or whoever the person is, and have some insight of basically what they want me to answer or what to discuss. Where it's kind of like almost like a 3-way call, sort of, where you would tell me what's going on with the client, and then I would talk to them or answer the questions, and either the client would then report to you, and then you may ask me, hey, is this what you actually discussed, and to get our notes right. But yeah, I mean, I have no problem with working with people as long as ultimately that's the goal. But the other issue is maybe you don't have to take every single client. And just because someone wants your help doesn't mean you have to take every case.
Right. And so explain the attorney-client privilege so that our viewers understand what that means.
Sure. So the attorney-client privilege is basically anything you say to me as your attorney is privileged information that I can't divulge that information to the court or to opposing counsel or really anybody without your permission or consent. The problem is if you then have a therapist in the room or a friend, a significant other, or some other person in the room, then that person is not bound by that confidentiality. And or it puts the therapist or the other person on the spot, that maybe what happens if they're called or subpoenaed to come to court, to say, hey, that you were present, aren't you? Because then potentially you're waiving that privilege, because obviously if you're talking about sensitive information that you may not want me, your attorney, to divulge, then by having you're diluting that by having other people in the room. because then the court could potentially say, well, then how confidential was it that all these other people were listening or were involved? I mean, in the grand scheme of things, it's not, it doesn't come up that often. Because obviously I as your attorney am trying to prepare you for something. This is not like a criminal case where you may confess that you did something. And family law is more nuanced about that, and because it all comes down to factors and in case law and what a judge is looking to hear about the best interest of the child, or just going over property issues. But obviously, if you blurt out to me that, hey, you have secret offshore accounts or something, it's not my place to really say anything, or I can't, right? But obviously, if you threaten to kill somebody or whatever, there's certainly things that have ethic rules that I have to provide, or I have to disclose, or it just creates ethical problems for me. But yes, ultimately, for a attorney-client privilege is just basically it's the same way with doctor-patient in medical fields. What you say stays with me, and I can't divulge it. But again, don't start having extra people in the room.
Yeah,
problems.
I kind of explain it to them. It's kind of like a Catholic confession, that when you confess your sins to your priest, they can't say anything. And if somebody else overhears the confession, then they can say something. So I explain to them that. And I personally don't like to go into attorney meetings for that reason, to protect the client. If the attorney and or the client wants me there to take notes to make sure they're understanding, and in the cases that I have done that is because we've got some mental issues that we're dealing with, or we've got some language barriers that we're dealing with, and I will help the client with that if need be. But I personally prefer them to be alone with you and have them communicate with you for their protection. So I think that's important for some of our viewers to understand as well.
And the other issue sometimes is who's the client, because sometimes I have way too many times where, say, grandma is calling me on behalf, or a significant other is calling me on behalf of the father or some other person who's at work or sick or just can't work or unable to talk to me, and the other person is really the client, but it's coming through the wife, spouse, or significant other. I'm really, my contact person is a third party, and it gets awkward because or whether the client comes to meet me, but their parents or other people are in the room. Again, do I have authority to talk to that person, or to give me authority to talk to a third person? It makes it like, again, who's the client and who has the problem? It creates problems.
It creates a problem for the attorney, in my opinion. I have been the go-to person in a couple of cases where the person totally did not understand, simple mind, and couldn't understand things. So I would come in with an agenda already given to the attorney, and I would have the questions already printed out for the client, and we would just go from there. I would keep notes, and the attorney would actually work with me as opposed to working with the client, because the attorney could understand what I was doing. But that's not something I prefer to do. I want to be there to support my client, and to me, to have my client be able to have that attorney-client privilege is legal protection. And so that to me is the most important for my client.
No, I agree, because it's also putting you in a bind.
Yes.
Because again, you may fully think or believe you understand what your client wants, but after not working with counsel, when you say if you and I are drafting an agreement, but then for the client to sign, what happens if they don't fully understand it, or they change their mind later, like, I never agreed to that, or they're now in court being voir dired, which basically means the judge is saying, are you entering this agreement freely and voluntarily? As your attorney answered any and all your questions, things like that. The judge doesn't want to hear, well, actually, I didn't actually review anything my therapist did at all. That won't bode well, or that causes.
And the specific time that I set into that, They would talk to me, I would explain to them and let them answer it. It was just the oddest thing. And they all wanted me. The attorney wanted me there more than the client even did, because they
Sure.
had such a struggle. So that brings me to a question that, because you've practiced in 2 different locations, so many people say, but you work with attorneys, you should know these answers. Well, one, I'm not an attorney, I can't give legal advice. But since you have worked in 2 different locations, explain to the viewers why it's so important that their legal advice comes from somebody in their state and county.
Well, because unfortunately, each state has different rules. I mean, family law in general is kind of based on the common law. If you would remember your history lessons of, like the Magna Carta and all this other stuff of like basically the kings and queens and and royalty and all that stuff. I mean, family law is sort of it just is kind of natural out there, but each state has codified rules and procedures for family law for divorce and custody cases differently. For me, I'm licensed in both Maryland and Pennsylvania. Ironically, while my office is here in Towson, Maryland, I am also licensed in PA. I was actually in York, Pennsylvania this morning. It's about an hour north of me, and over the PA line in front of a judge for a pretrial conference. And the laws are totally different there. And what I mean by that is when you file for a custody case in Maryland, you just file a case and then we have a certain procedure and we have our rules of civil procedure, which are the same in all counties in Maryland. But in Pennsylvania, you have a different set of rules, and each county has its own special local rules. So when I say know your court, know your judge, it's different in Pennsylvania versus Maryland. In certain jurisdictions of Pennsylvania, when you file a case, you're assigned a judge. So that same judge has especially set your case throughout the whole case. In Maryland, you don't find out who your judge is until the night before the hearing. So I mean, there are some major differences. The classic examples in Pennsylvania, child support is based on net income, and Maryland, it's based on gross income. And more glaring issues if you have in Pennsylvania, if you're looking for, say, spousal support, so you're married but don't have any children, then spousal support right off the bat is 40% of your net income would potentially go to your spouse. In Maryland, we don't have that. We just have alimony with no set. We have like factors, but there's no set formula. So again, you have to know your state. And rules matter. In Maryland, we have motions. You file a motion. The other side has 18 days to file a response. It's all done through the mail, and very rarely does the court order a hearing. Pennsylvania, it's motions driven. You have to give a week's notice in certain bigger cities or smaller cities, only 48 hours notice, and then line up to go see the motions judge in court, and to hear your motion. So I'm just different procedures and processes. So that's why it matters. I can answer a generic question. If you're in Florida, what may happen. I don't know specifically how the courts handle things. I can give you the generalities because every state has their specific cases and factors. But I can answer a general question. But if you're asking me what would a Florida court do or some other court, I couldn't answer that. And I don't mean to say, hey, ask a local lawyer, but a lot of times, you can have forum shopping. I have lots of people calling me from, other states, a lot of North Carolina and other places, that one of the parties lives in Maryland, or there's a custody order in Maryland, and then they now move to North Carolina or somewhere else. Should they file there or file here? Those kinds of things. So you get jurisdictional questions like that, and we can talk about minimum contacts and where does the child live the last 6 months. Is it worth filing one place or the other? But in general, but it matters where the court is. The same way it even matters which county you're filing in different states. In Maryland, again, they try and say there's no local rules, but that doesn't really mean anything. We have different case management systems in each county. So they process the cases differently.
Well, and then I also see that each judge handles cases a little bit differently. So even though you're following the same rules, same laws type of thing, you can be in front of a different judge today than you were 2 weeks ago, and you can have a
Right.
different way to rule.
That's correct. And especially here in Maryland, you have at settlement court, they're mostly retired judges who don't get you. They were so that they're not going to be your trial judge. I was in front of a pretrial conference in Pennsylvania. The judge clearly made it very clear that he will be the judge hearing the case in August when we come back. So, which changes the whole dynamic of the settlement court, because whatever is being said potentially could be remembered and used against your parties in the future, as opposed to just talking freely with someone who clearly has no skin in the game other than to try and settle the case.
Mm-hmm. Mm-hmm. Yeah. So, and as we get ready to come to the end of this, we've got all of your contact information below and everything, Richard, but tell people how they can find you.
Sure, they can find me either on my website at www.lebovitzfamilylaw.com. That's my last name, Lebovitz, family law, all one word.com. And I have a contact page. That's the quickest, the easiest way you can find me. I have a Lebovitz Law, page on Facebook. And I guess I'm on Instagram. Somehow I believe I don't really look at it. You can find me on LinkedIn and things like that, but primarily Facebook or my website. And I'm sure you have my email address, rdl@lebovitzfamilylaw.com. Hence, Lebovitz Family Law is my domain name, and RDL, my initials, would be my email. And then my office number is the 410-828-0680. That's another way to reach me. And I
Okay.
have a 24/7 answering service.
And so when they come to you the first time, do they need to pay to visit with you the first time, or is that a complimentary consultation?
I do charge $300 for a consultation, but I apply that as a credit towards any retainer. Obviously, then if you hire me, then you basically there is no fee. But essentially, yes, I do charge for my time, because essentially, if you're calling me or asking me to review a document or give you legal advice, and then you're relying upon it, the least I should do is be able to be compensated for my time. Because essentially you're trying to rely on my advice going forward. And I understand, as I think you said at the beginning, you have to make sure that I'm a good fit for you. And just because you may not hire me doesn't, if anything, I want to do my best to try and answer any questions a potential client may have, to make sure that they believe I may be a good fit. And of
Yes.
course, they can look at the website and look at my reviews and my blogs and see if they like me or not.
And I like that you charge, because then you are able to give the client legal advice as they move forward, whether that's, I've had clients go in and search for another attorney in the middle of their situation. And when they pay for your time, which they should have to pay for your time, at least then that legal advice is something that you can give, and it's something they've now paid for. So I like that. I think that's a good way to communicate in the very beginning, because they can get that legal advice. So I appreciate that. So are you on like Instagram or Facebook or anything else?
Well, I am on Facebook. I have I send out newsletters and things like that. Once you contact my office, then I would have your either your phone number or email, and I add you to my newsletter and send that information out. But yes, there is a Facebook page through Lebovitz Law, or mostly my website. I'm not really into social media as much. I believe there's a YouTube channel with 1 or 2 videos on there, and I just don't have the time to post stuff there. I'm sure in the future with more marketing, I'll figure that out. And I do the occasional pay-per-click and mostly search engine optimization.
Because I sit in on lots of marketing discussions with people. It's when you're as busy as you are, there's no need for you to market. You've got enough clients coming in, you're taking care of your people. So that's probably more important. So
Well,
for
sure.
our viewers, go ahead.
No, I'm saying I've been doing this for over 30 years, so basically you name it, I've tried it with regards to marketing. It used to be the yellow pages or the white pages, or being on having some kind of a directory. But honestly, after being out for a while, people either know you or they're searching, and whether it's pay per click or local service ads through Google or other companies. I just now with the organic search, it seems to be the best way to go.
Yeah, and
You know,
that it
so.
is. I have people that you go and you meet just on the street and they're Googling us right there as you meet them. So they're finding out who we are right there. And with you, yes, you can Google you and Google your practice and you can find you right away.
That's correct.
So very good. So for our viewers, I'm a certified divorce coach, meaning that I'm trained in the complexities of divorce. Not only am I a certified, meaning that I'm trained, I have also experienced abuse. I have helped my father out of an abusive relationship, and I helped my late husband out of an abusive relationship. So not only do I know it from textbook, I also know it from experience. You can find me or contact me through my email through coachtinalynn@gmail.com. That's COACHTINALYNN@gmail. My website is divorcecoachspecialist.com. You can also find me on social media on Facebook under Tina Lynn Huggins. That's Huggins. LinkedIn under Tina Huggins. On Instagram under Divorce Coach Tina Lynn. TikTok under Divorce Tina. And so one of the last things that I would like for you to do, Richard, is give our viewers some last little bit of advice.
Sure. Honestly, for me, I would really, I guess, do your homework, and don't be afraid to either reach out to an attorney, either whether myself or anyone else, to try and ask questions, because you're making everybody's job better if being an informed consumer to understand what your rights are. That's why when you're just calling around and you don't know your rights, that's when you get in the trouble, in the sense that you may have a spouse and you're like, I'm just tired of it. I just want a divorce, or I just want to sign. It'll be like, or give you papers, just sign this. But it's best if you know what your rights are. So whether you're calling an attorney, there's plenty of free resources out there, local bar associations, or other public service groups out there that can give you help with information. Or even just go to a law library, or lots of search engines online can give advice to try and answer questions. So I would just say it'd be best to do some homework and research, and don't just look for the quick fix, because if it's too good to be true, it probably is. Yeah, so at least it's always best to have a second opinion or some knowledge of moving forward.
Well, and I'm not even going to give any more advice, because that's exactly what I was going to say too. It's very important to have an informed decision as you get ready to move forward. So make sure you do reach out, and having legal advice. There's only one person that can do that for you, and that's an attorney. Divorce coaches can't give legal advices. CDFAs, which are certified divorce financial analysts, they can't give you legal advice. The only ones that can give you legal advice are attorneys. We can help you talk through those decisions, but having that legal information to have an informed decision is very important. So I want to thank you, Richard, and I want to let our viewers know that if you are in a situation now, a violent situation, please call 911. If you're in the UK, it's 999. Press charges. That's your key out of the abuse. Do not drop those charges. Most often, once the charges are dropped, what happens after is much worse than what's happened before. You can also, if you are involved or you know somebody involved, please call the domestic violence hotline at 800-799-7233. That number again is 800-799-7233. And I ask that you please like, comment, and share this so that it can help others. Thank you so much for being my guest tonight, Richard.
Well, thank you for having me. This was a pleasure.
And my hopes is that we get to have you come back.
I would love that. Thank you.
Thank you.